Thank you, Mr. President. I rise today to speak in strong support of the nomination of Judge Neil Gorsuch as Associate Justice to the United States Supreme Court. Now, Mr. President, as you know very well, there's been a lot of debate about Judge Gorsuch and his candidacy for the Supreme Court. Let me first review some of the things that really have not been debated. One is the intellect and the education and the knowledge of this man. It's really extraordinary. Judge Gorsuch attended Columbia University as an undergrad, Harvard Law School, went on to Oxford for postgraduate work. Nobody disputes the intellect, the education, the knowledge that this man brings to this job. Nobody disputes his experience and qualifications either. How could they? He has spent 10 years on the 10th Circuit Court of Appeals, the second highest level of courts in our American system. There's no question that Neil Gorsuch has experience and the qualifications. Character and temperament are extremely important, actually essential characteristics for a judge or a justice. I've heard nobody criticize the character or temperament of Judge Gorsuch whatsoever. In fact, he has only gotten glowing praise about both his integrity, his character, and his temperament, and the way he treats people in his courtroom and throughout his life. There's also no disputing that he has enjoyed very broad bipartisan support in the past and significantly to this day. First of all, there was not a single senator who opposed his confirmation to the 10th Circuit when he was nominated and confirmed. President Barack Obama's acting Solicitor General, Democrat, has endorsed Neil Gorsuch for the Supreme Court. And a bipartisan group of attorneys, former colleagues from his law firm, classmates of his, many people across the political spectrum from both parties who know this man personally have strongly endorsed his candidacy. So these very important criteria, his intellect, his education, his knowledge, his experience, his temperament, his character, everything about this man is really quite extraordinary. And that is not even disputed. That is almost universally acknowledged. So what is the attack? What is the criticism that we hear about Judge Gorsuch? Well, one is this notion somehow that he's outside the mainstream. We've heard this from some of our colleagues who intend not to support Judge Gorsuch. But you know, one of the things about being a circuit court judge is it's actually quite easy to evaluate whether or not a circuit court judge is outside the mainstream because, as it happens, appellate court, circuit court judges, they don't rule alone. They rule in groups. It's usually a group of three when they're hearing a case as a subset of the full court, or it's the entire court. But either way, they're ruling with other judges. And so you can evaluate, for instance, how often are they by themselves? How often are they the sole minority dissenting view? Because that might be an indication of someone who's outside of the mainstream. It's interesting. In the over 2,700 cases that Neil Gorsuch has decided on, in 99% of those cases, he was in the majority. In 97% of the cases, it was unanimous. How could that possibly be outside the mainstream? That's not a valid argument at all. So what the people who are trying to manufacture some opposition to Judge Gorsuch, what they are doing is they're cherry-picking a handful of the over 2,700 cases in which he's participated, and they try to find a handful in which Judge Gorsuch did not rule in favor of litigants that our Democratic colleagues believe are politically sympathetic. That's what their argument has come down to. The Democratic minority leader has been down on the floor in a speech, and I will quote from his speech. He says, and I quote, "I saw a judge who repeatedly decided with insurance companies that wanted to deny disability benefits to employees." The Democratic leader goes on to say, "I saw a judge who, in unemployment discrimination, decided with employers the great majority of the time." Another quote, "Time and time again, his rulings favor the already powerful over ordinary Americans." The Democratic leader went on to marvel, and I quote, Judge Gorsuch ruled against a teacher. Judge Gorsuch ruled against a truck driver. Now, Mr. President, even if you set aside the fact that the facts in these cases have been wildly distorted in the retelling that I have heard, if you set aside the fact that even in those very cases in which Judge Gorsuch has ruled, often he has ruled with Democratic judges who enjoy the support of our Democratic colleagues. Even if you ignore the fact that in many of these cases, he was bound by precedent, he had no choice. Or you could ignore all the many other cases in which Judge Gorsuch ruled in favor of workers and unions and people who allege sexual harassment, environmentalists, immigrants, other sympathetic litigants. So you put all of that aside, I think we have to ask a fundamental question. What's missing in this critique of Judge Gorsuch's decisions? What I find striking is that what is missing is any reference to the law. I don't hear them mention the law. They don't say, I've not heard any of our Democratic colleagues who intend to oppose Judge Gorsuch say that he ignored the law, or that he violated the law, or that he misapplied the law, or that he misunderstood the law. I don't hear anything of the sort. Now, why do you suppose that is? I think I know why that is. I think because to many of the people who are threatening to oppose Neil Gorsuch, the law isn't what really matters the most. What really matters the most is that politically favored special interest, or someone that they think the public will be sympathetic to, has to win regardless of the law. They want a policy outcome, and one that will benefit their perceived preferred litigants rather than the law. Here's what I think really think there are two unpardonable offenses in the minds of our friends and colleagues who are opposing Neil Gorsuch's nomination. The first is that Judge Gorsuch believes in the rule of law. I know he does. It's very, very clear. And to some degree, there's a fundamental debate going on here between those who support his candidacy and those who oppose it. And it's fundamentally about the role of judges in the U.S. constitutional system. See, one view, the view that I have, and I believe that Judge Gorsuch shares, is that the law totally matters. What the law says matters, and that includes the Constitution. The words matter. And not only that, it's up to the American people to change laws or to change the Constitution if the American people see fit. It's up to judges to apply the law and the Constitution as it's written and impartially. And that's the important thing here. Both of these are important. See, a judge, under our view of the world, a judge is supposed to see everyone the same, regardless of race, sex, wealth, political affiliation, or other characteristics. A judge is obligated to neutrally apply the law. Whether you're a man or a woman, young or old, rich or poor, black or white, that's not supposed to matter to a judge. You know, there's a reason that our symbol of justice, Lady Justice, is depicted wearing a blindfold. It's because you're not, as a judge, you're not supposed to decide based on these characteristics of a person. You're supposed to decide based on what the law says. This is very fundamental to an independent judiciary, to a nation that lives by the rule of law. But the other view, the critics' view, they constantly go back not to the law or the application of the law, but to how sympathetic the litigants are. That's what matters most to them. That is an implicit rejection of the notion that everyone is equal before the law. Instead, in that worldview, some are more equal than others. The law means whatever a judge thinks it should mean, and that's based significantly on who the litigants are. And the same applies, by the way, to the Constitution in their worldview, that of those who are opposing Judge Gorsuch. The Constitution can't really mean exactly what it says, because that can be very inconvenient. And so what the Supreme Court is supposed to be in the minds of our friends who are opposing Judge Gorsuch is the Supreme Court is really a permanently sitting constitutional convention. You can make up the Constitution as it goes along, decides what it means today as opposed to what it meant yesterday or what it might mean tomorrow. And in their view of the world, judges are supposed to be acutely sensitive to the race, sex, wealth, political affiliation of the people who come before them, and those criteria matter a great deal. In fact, you have to ask yourself, if that's the way you view the world, why even bother having trials? Why not just have a little checklist and see whether the litigants come down on the politically sympathetic side of the ledger or not, and when you know that, you know the outcome of the case. Why be bothered with the hassles of a trial or a case? I would suggest, Mr. President, that this approach to the law, a law that depends on you name it, the sex, the race, the age, the ethnicity, or any other criteria of the litigant, such a law isn't really a law at all. That's how a banana republic imposes laws. That's not how the United States of America does. So my view, as I stated earlier, that the law means exactly what it says and nothing other than what it says, and that also applies to the Constitution, that's a view that's often described as originalism. And the opponent view, especially with respect to the Constitution, they believe that the Constitution is a living document. So its meaning changes over time in their view. I would suggest that this is a fundamental choice between the rule of law in the former case and rule by judges in the latter case. Justice Scalia once said, and I quote, "Every tin horn dictator in the world today, every president for life, has a Bill of Rights." The Bill of Rights, end quote. The Bill of Rights only protects us if it's enforced, and if it's enforced consistently, identically, and equally for everyone who's involved. How much protection does our Bill of Rights provide if, as Chief Justice Hughes stated in 1907, quote, "The Constitution is what the judges say it is"? Oh, whoa. As Justice Scalia observed, once the original meaning of the Constitution can be set aside and judges can rewrite it, then they can rewrite and limit individual liberty or any other of the rights that are so fundamental to the nature of our country. Let me give a tangible example to make this very specific. There's a case that came before the Supreme Court not very long ago. It's called the Kelo decision. Now, the Fifth Amendment states very clearly that the government cannot take private property unless it is, and I quote, "for public use." That's what it says in the Constitution. You can look it up. Well, in the Kelo case, 5 Supreme Court justices decided that public use can mean private use. That the word public can mean private. And specifically in this case, what they said was that the government can come along and take an individual's home and give it to a private company, in this case to use as a parking lot for private venture. This, Mr. President, is blatantly unconstitutional. It's very, very clear. But yet, that's what happened when 5 judges decided they could just rewrite the Constitution as they preferred. And here's the thing about this. Even if you believe that it's a good idea to be able to take someone's house and give it to another private developer because he's got a better use for it than the homeowner. If you think that's a good, I don't happen to think that's a good idea, but you might. And if you do, we have a mechanism for making that policy permissible. You change the Constitution. We've done it many times. You amend the Constitution. You could strike that word, or you could insert another clause. There's any number of ways you could change that. But here's the thing that's so important. Under our constitutional system, the only people who get to change the Constitution are the American people. They do it through their elected representatives in the Congress and in the state legislatures, but they're the sovereigns. It's the American people who get to make these decisions, who determine policy, not 5 unelected guys wearing black robes. Because when they get to make that policy, they're not accountable to anyone. They can't be fired. Mr. President, you and I can be fired. If we're not doing the job that our constituents want us to do, we will be fired. That's how we're held accountable. Our constituents can replace us with people who will reflect the policies that they want. That's why we are the policymakers under our constitutional system. I believe Neil Gorsuch completely understands this. And it's one of the reasons our friends on the other side of the aisle can't bring themselves to support him. But I said there were two unpardonable sins that Neil Gorsuch has committed. I just mentioned the first. I think the second one is that he was nominated by Donald Trump. Now, we've got folks in this chamber who don't seem to be able to accept that they lost an election. And they are reflexively opposing whatever it is that President Trump wants. And apparently they intend for that opposition to continue indefinitely. Again, the minority leader in a public interview was quoted as saying, "It's hard for me to imagine a nominee that Donald Trump would choose that would get Republican support that we could support," end quote. And then there was a follow-up question. He was asked, "So will you do your best to hold the seat open?" And he replied, the Democratic minority leader, "Absolutely. Just going to hold the seat open for 4 years or maybe 8 years?" Mr. President, this is outrageous. And it's unprecedented. I mean, if the minority leader were to get his way, for the first time in the history of the Republic, we would have a Supreme Court nominee defeated by a partisan filibuster. Let me stress this. This has never happened before in the history of the country. How many times have we nominated and confirmed Supreme Court justices? Never once have we had a partisan filibuster used to block the consideration of a nominee. We've had people withdraw. We've had people who were voted down. The case of Abe Fortas is an unusual case where there was a bipartisan filibuster because there was a perception of ethics problems, and he, in fact, had to resign as an associate justice. The bipartisan filibuster was used when there was an attempt by President Johnson to elevate him to the Chief Justice. So that's not a precedent. There is no precedent. Or take the case of Clarence Thomas. In my lifetime, I'm pretty sure that Clarence Thomas was the most controversial nominee that we've ever had. It was a brutal, very, very difficult, very contentious, really ugly process, the whole hearings, the nomination process, the confirmation process. In the end, Clarence Thomas was confirmed with 52 votes. Now, any senator in the body could have insisted on a 60-vote threshold. The tool was always there. But nobody did. No senator did. Because the custom has been that Supreme Court justices get confirmed if they have a majority of support. So what the leader the minority leader wants to do is completely depart from that and establish a new threshold. Now, the minority leader has made this argument that is really, it's absolutely laughable. He has suggested that because President Obama's nominees got 60 votes, well then, President Trump should. What's laughable about this is the reason President Obama's nominees were able to get 60 votes is because Republicans gave them votes. I said, I was running for Senate at the time that Sonia Sotomayor was nominated. And I pointed out publicly, look, there's a lot I disagree with her. I'm sure I will not be happy with many of her decisions, but you know, here we are in the beginning of a president's term, relatively early in a new president's term, and this is a qualified, capable person. I'm not going to obstruct. I would vote to confirm her, and a number of Republicans did join the Democrats, and President Obama got Justice Sotomayor and Justice Kagan confirmed to the bench. The minority leader has suggested that there's this tradition of 60 votes. Well, you don't have to take my word for it. The Washington Post fact-checked, the Washington Post, mind you, not exactly the mouthpiece of the Republican Party. They did their fact-checking analysis, and they said it's absolutely false. They gave him 3 Pinocchios. It's also, one of the many ironies of this, is that the very same Democrats who insist that we should allow them to permanently block any Supreme Court nominee because they won't provide the votes to get to 60, are the ones who actually did break the Senate tradition and establish a 50-vote threshold when they wanted to pack the D.C. Circuit Court of Appeals back in 2013. Now they're suggesting that if we use the same tactic that they used, although we'd be doing it for a very different reason, that this would be an abomination. So they say, well, Democrats would never do this. Well, actually, they did in 2013. But as for the circumstances we face now, there's no mystery about what they would have done because they told us. Just 12 days before the election, our Senator Tim Kaine was the Democratic nominee for vice president, and he was asked, he said, well, what happens if, as everyone expected at the time, Hillary Clinton becomes president and the Democrats take control of the Senate? If Republicans were to filibuster a Supreme Court nominee, what would you do? And I will quote Senator Kaine. He said, "We will change the Senate rules to uphold the law that the court will be 9 members," end quote. Here's the truth of the matter, Mr. President. If the election had gone differently, if Hillary Clinton had won, and if Democrats were in control of the Senate, then probably Republicans would have provided the votes for a competent, capable, qualified Supreme Court nominee, just as Republicans did for Elena Kagan and Sonia Sotomayor. That's what the history shows. But unfortunately, our Democratic colleagues at this point seem unwilling, or at least some of them, to provide the same bipartisan cooperation to a new president attempting to fill a vacancy that Republicans provided to President Obama. Let me conclude with this. And I think the case for confirming Judge Gorsuch was summed up pretty well by the editorial board of the Chicago Tribune, again, not exactly the RNC's mouthpiece. And in endorsing Neil Gorsuch, they said, and I quote, "Here is a judge who knows the law and knows the role of the judiciary. He isn't on the bench to make law. He's there to interpret it faithfully, because the separation of powers among the branches of government serves our democracy. Sometimes the results benefits liberal positions, sometimes conservative. Some of Gorsuch's critics think judges should be creative and expansive depending on the political climate, to treat laws differently on a cold night than on a warm night. Those critics suggest that they fear Gorsuch won't follow the law, but the opposite is more true. They fear he will. Gorsuch should be confirmed." Mr. President, if our Democratic colleagues aren't willing to confirm Neil Gorsuch to the Supreme Court, then there's no one that they're going to confirm to the Supreme Court. And we cannot allow a Democratic minority to block an up or down vote and deny filling a vacancy on the Supreme Court for 4 or 8 years. We simply can't allow that to happen, and I trust that we won't. And I note the absence of a quorum.